Welcome to another installment of Employee Termination Tips. My name's Christopher Neufeld of Neufeld Legal. And in this particular video, we'll be discussing some more items that you should be asking of your former employer immediately after you've been fired. Now, in a previous YouTube video, we discussed the importance of asking for employment records, documents, contracts, given the fact that you've been more than likely locked out of your office computer, your office phone, and been walked out the door and told that you can be provided with your documents later on. And in fact, what you do need is a lot of documentation to make a proper assessment and review of your termination severance pay package and what you should be doing next with respect to the offer that's been put forward by your now former employer. But what most employees don't do and don't even realize, and even the employers oftentimes don't realize, is that in addition to requesting hard copies or digital copies of records that were created from the past, what you should in fact also be requesting, and this is going to set off your employer even though they're legally obligated to provide it to you, is that you should be requesting computations and methodologies of how they calculate important employment-related aspects of your pay, because this is critical and determinative to how they calculated your termination and severance pay package. So what are you in fact requesting? Well, one of the things you're requesting is how they calculated your earnings, but also how they calculated and the method they used for calculating your bonus and your living allowance if you were paid either of those. You should be requesting those things. Also, whether or not that bonus and living allowance formed part of your wages. So these are critical things to a lawyer especially, but even to yourself, to understand and try to articulate where you stand relative to the termination severance pay package you've just been receiving. And these items are specifically required to be provided by the employer to the employee by law. It's in the legislation. The employment standards legislation specifically requires this to be provided for. And the fact of the matter is, oftentimes employers do not like providing that information. This information is problematic to the employer because it means that the employee knows that there could be something that was done improperly and that there is more to it than what the employer necessarily understands right now. And when you ask for it, it could well set them off. But the fact that they deny you this information is important information that you need to consider, because this is not simply a matter of transparency and an issue of whether or not they wish to provide you this information. They are legally obligated by statute to provide it to you. That means there's no entitlement to refuse. They must provide it to yourself. And if they decide not to provide it to you, that raises serious questions. They're either effectuating a power play or they're attempting to hide something. And in both circumstances, you need to consider what that means. It means they're trying to lowball you with respect to your termination severance pay package. At least that is our professional opinion as to those situations. And when they do this, that is when you most definitely need to speak to a lawyer who is knowledgeable about these matters. You should be speaking to a lawyer irrespective, but when they are refusing this request, which is mandated by law, that is when you really need to talk to a lawyer and get the lawyer to address this situation with yourself, because this is only the tip of the iceberg oftentimes, because they're trying to do something that they are not legally entitled to. And what does that mean? Typically, it means there are more issues lying beneath the surface of this proverbial iceberg that need to be addressed. And that is our tip with respect to requesting calculation methodologies from your employer. Thank you.